Hello everyone. A very warm welcome to our interactive Ask Me Anything session for today. I'm Advocate Nikhita Kohli, Assistant Vice President Legal at NRI Legal Services. Today we will be taking up the topic of NRI property disputes and how to settle them amicably. Before we begin, I would like to ask my colleague to introduce herself.
Hello everyone, this is Advocate Alicia Monga, Senior Legal Associate at NRI Legal Services.
Moving on, today we're going to be taking up the topic of NRI property disputes and how to resolve them amicably without initiating a legal battle. There are solutions, that's why we are here to guide you. Please stay with us till the end. Now, what are the common legal disputes faced by NRIs and what are the challenges faced by them? NRIs often encounter various types of legal disputes due to their absence from India. Understanding these common important issues can help in taking proactive measures to mitigate them and help in resolving the legal disputes from overseas. Let us now take forward all the property disputes one by one with you.
Yes, so I will bring that up. There are common types of property disputes that the NRIs face is firstly property disputes, ownership disputes, then there is illegal occupation, then there is conflicts with the co-owners. Ownership disputes can often arise where there is ancestral property involved and there is unclear titles. Then there is illegal occupation. Illegal occupation can be there when, especially in the cases of NRIs, because they are absent from India physically for a prolonged period of time. And then it ends up that these squatters and encroachers, they trespass on their property and they refuse to vacate the property. And it creates a lot of legal challenges for the NRIs. So to counter this situation, it is very pertinent that the NRIs regularly monitor their properties through a trustworthy relative or a caretaker. Then there is a conflict with the co-owners. This situation arises when there are huge chunks of land and the boundaries are not ascertained. Again, to counter such a situation, it is advisable that you should get proper demarcation of the land and build a boundary wall so that one can ascertain their piece of land. Moving on to next, then there are family inheritance and succession disputes. If we talk about, there's a burning topic related to the will.
Ambiguous. I think, Alicia, that's your favorite topic regarding the will.
Why not? So, ambiguous will. Lack of a clear, concise will creates a lot of confusion with regards to the distribution of the property of the deceased. We even had, you remember we had an example where a father, in the beginning paragraphs of the will, bequeathed 1/3 share to his 3 sons. However, in the subsequent paragraphs, he just gave the share to 2 sons. And today, due to this unclear will, there is multiplicity of litigations pending. So to avoid such a situation, you should take help of a legal advisor and write a legally sound will. Another type of...
Alicia, I would like to bring on one point here. In cases of will, we always advise our clients, generally if they are making it and if, of course, when there is already a will, which is a very important point, that if any legal heir is exclusively, omitted from a will, or I would say he's not been given anything, not omitted actually, not given anything, that reason needs to be mentioned in that will. So अगर आप किसी एक legal heir को जो testator है, he is not giving anything to that particular legal heir, he needs to specify a reason कि reason क्या है उनको ना देने का, because otherwise बहुत suspiciously आप wills को देखते हैं कि उनका नाम ही नहीं mention किया हुआ. So that becomes very important that way.
Exactly. And on that note, there is another type of succession dispute with regards to, I would say, when there are multiple legal heirs. So it is very difficult to ascertain who is the rightful legal heir. In such a situation, you can approach the court and get the succession certificate and legal heir certificate so that you can clearly establish who are the rightful legal heirs.
Then a third kind of dispute would be disputes with the tenant, which is of course most commonly prevalent in India in cases of NRIs, because they have their properties, then they give it on rent. Sometimes they appoint a caretaker who can further give it on rent. So tenant disputes कब आते हैं? When there are no proper rent agreements with the tenants, and then there are issues like non-payment of rents by the tenant and unauthorized subletting by the particular tenant. So उन cases में when also there are cases like nuisances being created by the tenant. So in kind of scenarios में it is very important to have a proper rental agreement. Otherwise, of course, these disputes are very much prevalent in India between an NRI landlord and a tenant. And moving on to the builder-buyer dispute, which is another kind of dispute between a builder and a buyer. In cases mein, what happens is when there are quality variances in terms of handing over of the property, there is a delay in handing over the possession of the property and violation of any contractual agreement between a buyer and a builder. So in these kind of scenarios, these disputes arise between a buyer and a builder. So in these situations, we always advise our clients to have a proper communication with the builder to ensure that there is a proper documentation. Always try to invest with the builders who have a reputation of meeting deadlines and complying with the regulations, rules. And most important, always try to make sure that the projects in which they are investing, they are registered with RERA.
Exactly.
So that is very important. That needs to be taken into consideration.
Exactly. And also one should check before investing. You should do a due diligence on the builder itself these days, because a lot of frauds are happening with the builders these days. So you should check their status, that they are active, they are complying with all the property laws.
Exactly.
And so on.
In fact, Alicia, there's another point also that documentation अगर आप लोगों का complete होगा किसी भी situation में, if the documentation is proper, then there will be no problem otherwise to approach the court, because documentation proper होने की वजह से you will have I would say stronger stance while approaching the court. So that is very important in that scenario.
Exactly.
Yeah.
So now I think we have broadly covered the types of disputes that majorly the NRIs face. And now we would like to shed some light on its resolutions.
Yeah.
So firstly, I would say that it is very difficult for the NRIs sitting miles away to resolve their disputes. And these complexities are there due to the different time zone, then the unfamiliarity with the local laws that are governing. So it is firstly very important for the NRIs that they should be abreast of the local laws wherever their property is situated. Then there are, I would say, different modes of the settlement, which namely are mediation, negotiation, settlement, arbitration, and so on. However, each of these, they have their own modus operandi, their own advantages and their own challenges as well. So now one by one we will just explain you all these modes. And first I will take up mediation, right? So mediation, I would say, is a very, I would say, confidential and a private process to solve your dispute. Because you need to intervene, a third party intervenes as a mediator, and it helps both the disputing party to reach a common resolution. And it is a very, I would say, cost effective process. Then litigation, because litigation is cost effective and it takes years and years to conclude. So NRIs can definitely opt for mediation, and especially I would give some light on the Mediation Act of 2023, right? And its main objective were that the parties in the pre-litigative stage should approach for mediation, and even if they do not approach, even the court can at any point of time, at any stage, can refer these litigating parties for mediation.
And moving on to the next one is arbitration. So arbitration basically involves an arbitrator on a panel of arbitrator who hears the arguments from both the parties and makes a binding decision. Again, arbitration is cost effective and like time saving it is. And in case of arbitration, there is an Act of Arbitration and Conciliation Act of 1996, which provides a robust framework for getting into arbitration. And then there is, of course, See, there are complex NRI cases. So for that, these settlement modes like arbitration and mediation, these are very less time taking and of course cost effective, which becomes easier for the NRIs sitting there and getting their matters resolved here in India. So that is when it is traditional, but then it is less formal again than the normal court case hearings. So that is how it is for the arbitration. Then there is another resolution mode is the family settlement. Family settlement, as the name suggests, it is the settlement amongst the family members. So what happens is a lot of times clients come up to us, they have family settlements already with them. In those kind of scenarios, the family settlement is already there. That has already been executed amongst the parties who are legal heirs, who is having the inheritance over a property. And in other cases, there are clients, of course, they want to enter into any kind of family settlement to resolve any dispute further in future. It is very important that family settlement should be registered and executed amongst the family members, having the consent of every person involved. So that is one. And then again, it is less time taking, and if there is a family settlement, it should be signed by all the parties. So these are the modes. Resolution, this is another type of resolution for getting the property dispute resolved.
Right. Team, can you, there's a technical this thing, can you help us read the questions?
Okay, then there is another topic of we can take up litigation.
I think we have questions.
Okay.
I'll take up the question first.
Yeah, we can take up the questions first, then we can move on with this. Yeah, all right.
So there's a question by Akshay which says, hello, benefits of family settlements in resolving NRI property disputes. So while you just explained about family settlements, I'll take up this question.
Okay.
So see, family settlements, I would say, is the most easiest, confidential, private mode of settlement, because family property disputes are very, I would say, emotional in nature. They are very sensitive in nature and very intricate in nature also. And then the second benefit would be that even if you're sitting abroad, you can authorize a trustworthy person, you can give your power of attorney, and then on your behalf he can enter into the family settlement. And thirdly, I would say it is a financial prudent decision. Why? Because it is less expensive than the court procedures and the litigation. And it also promotes open dialogue, because when families are sitting together having discussions, everybody can keep your viewpoint and enter into settlement. And for the time being, I even see another question.
Okay.
Yes. So we have, my father is in London and invested in a real estate project in Gurgaon. The builder was at default and we went for litigation. The matter got decided in our favor. Still, the builder is not refunding us the amount.
Okay. We have a lot of typical kind of cases with us. Thank you for the question. I'll take up this one for you. See, if you have a favorable order with you, that's again, there's a plus point that you have, of course, you have a upper stance in this matter. You can always, legally, you can always go for an execution of that judgment, right? And of course, once you will file an execution, most of the builders, they do not turn up in the previous stages, but then at the time of executions, they do turn up, and of course, to avoid any adverse orders being passed against them. So execution is one legal route that you can file for, but again, since we are taking up the topic of amicable resolutions, you can always tell your lawyer, who's of course representing you in the matter, who's represented you in the matter, you can tell the lawyer to approach the builders also, or the counsel of the opposite party if they were represented earlier, to look for any kind of settlement in this matter. Because see, if you will approach the court, it will be prolonged, but then of course if you want to get it settled through approaching them and amicably getting into some kind of negotiations with them, you can do that as well. So I hope that explains your that clarifies your query.
Yes. Moving ahead, I think you just explained family settlements, and there are few other modes of settlement as well. So I would say negotiation and settlement are another processes that you can opt for settlement. Direct negotiations can be made between the disputed parties, and negotiation is a very flexible and informal process, of settlement. And again, it is way less expensive than the court procedures. And at last, I would also say that if all these modes do not work, then litigation is the last resort. You can approach the court of law. The judge will pronounce a decree, court decree, basis on the arguments and evidences presented by both the parties. And then the parties have to bind by the decision of the court.
Litigation, Alicia, I would like to put on one point. See, litigation as such, of course, we have put in this point in this video for a reason. We'll tell you why. That litigation as such is not a mode of settlement, but a lot of times what happens is parties are not able to approach each other. Like, there's a family dispute. One family is not even in talking terms with the other family member, and of course they want to approach them, but they have that ego clashes and of course, when you have those kind of situations, it is very difficult to approach them amicably. So in those kind of scenarios, what happens is a lot of times, and it has happened also with our cases, that we file a matter, the opposite party turns up in the case, and then of course they come up with some kind of negotiation, they turn up with some kind of offer during the litigation proceedings as well. And in that case also, we are ultimately having a family settlement be drawn up during the court proceedings, and that settlement will be a part of the court case. So that will be on record, and the matter of course will be resolved by way of settlement between the parties. So that will be, in a way, we can say it will be a settlement within the court. Exactly. So that's how that settlement takes place. So I think
exactly. And also I think in the cases of NRIs, litigation is the most viable option of settlement if the other modes do not work. Yeah. So I can see another question which says, hi, my cousin is a Canadian citizen. His father left a will, but the contents of the will are confusing. There are 3 brothers and a sister. How to deal with such a situation? Will, again, this is a very burning topic, and I would say from the question it appears that the will in question is ambiguous. However, I would say that if it's an ambiguous will, it doesn't mean that it is automatically invalid. And it doesn't also mean that the beneficiary will not be able to get any estate of the testator. If there is ambiguity in the will, firstly I think if the family members are involved, you should try and sit and resolve the matter amicably. If you are not arising to any resolution, then obviously you have the court, you can approach the court and get the will validated and authenticated in the court. Yes. And I can see a lot of queries are coming up. And another one is, hello, I am 70 years old and purchased a plot in Mohali. I have a dispute going on with builders since 2007. How can I get rid of this court case? You want to take up?
I'll take up. Let me just read the question. I have a dispute going on with the builder. Mr. Rakesh. Mr. Rakesh, looks like from your question that whatever dispute it's been going on, I assume that it's a court case which is going on in the court. Considering that, see, if you have very strong documentary evidences with you, and you have approached the courts with all the complete documentation with you, and you have the proofs, we will advise you to go through that litigation and present your case accordingly. Of course, there must be a lawyer representing you. Go through that court case proceedings, and if the matter is, of course, looking like considering the matter is strong in your favor, then there are high chances that a favorable decree be passed in this matter. And once you have that decree with you, you can always go for execution. I just explained in the earlier, I think there was a question earlier as well. You can go for an execution. But again, there are chances that during the court case also you can approach, the opposite party can also approach you, or you can always approach the opposite side for any kind of negotiation, just to get rid of that litigation. So that, see, this kind of cases in the builder disputes, I think we have been dealing with in our day-to-day situations we are dealing with. But in those kind of scenarios, the interest rate may fluctuate. Since we are getting into some kind of negotiations and settlements, the interest may variate. But then if you have to get rid of litigation, that is another way of, to get the matter resolved.
Because ultimately I think it's in your best interest. Because litigation is, at the end of the day, it's mentally exhausting, heavy on the pocket and everything, right? And I can see another question by Ms. Bhavna Goyal, which says, I am not an NRI, but I want to know the essentials of a compromise deed. You would like to
Alicia,
take
I will take up this
All right.
question. Compromise deed. Again, it is like family settlement. I just explained. This is another kind of document. Compromise deed. Again, whoever is a party to that compromise deed has to be in consent. Everybody needs to be on the common page when you're entering into a compromise deed. It needs to be signed by all the parties. It needs to be witnessed by 2 attesting witnesses, and it should be in proper writing form. And that is one. And of course, I think, would you like to add on some point? I think compromise deed, I think pretty much it's covered. Basically, see,
Yes.
it must be in writing. All the parties should be signing it, and the witnesses has to be a party to that compromise deed. Most important, it should not be vague. It should be clearly mentioned. The clauses should be clear, so that to avoid any future dispute. So it should be very clear whatever you're writing in that compromise deed. Yeah.
Exactly. So another question again on compromise deed, which says, my friend is a resident of America and has an ongoing dispute with Delhi-based reputed real estate company. However, now they have entered into a compromise, but still they are delaying the payment which is to be paid. What to do in such situation? Again, it is regarding compromise. I think the viewers have a lot of curiosity regarding compromise deed. So I will take this up. See, whenever you must have entered into the compromise deed with the builder, there must be a defaulting or a penalty clause. So refer to that, and if the builders are not paying you according to the payment scheduled as mentioned in the compromise deed, you should approach them first informally. Try to negotiate with them, and or maybe tell your legal representative to approach them and remind them of the compromise deed. And even after all these efforts, they still do not comply by the compromise deed, then ultimately you can take them up in the court and get this compromise deed upheld. And I also have a judgment here. It was by the Supreme Court, Sita Ram Bhana versus Ram Bhana, which says that once the disputed parties are signing to the compromise deed, that means they are doing it voluntarily. And then they should honor the contents, they should honor the compromise deed, and in case of any violation, you can get this compromise deed enforced by the court. Yeah.
Do we have another?
We don't have another question at the moment, but I think I would also like to explain another type of property dispute. Basically, we also deal a lot of fraudulent property transactions. This happens in the case when there are fake property documents made, and which majorly happens in the cases of NRIs, since they are not physically present here. So maybe any, I would say, third party, or maybe the relatives who have certain evil intentions, they make fake property documents and enter into fraudulent sale deeds and transfer deeds, etc. So to curb this, NRIs should again monitor their properties daily on a regular basis, and should also update their revenue records timely. And another also the issue that is faced is that misrepresentation and impersonation. Again, whenever you're issuing a power of attorney, make sure that you are issuing it to a very trustworthy person, and once the assigned tasks are completed, you should immediately revoke such power of attorney, so as to avoid further misuse of that power of attorney. Right? And I think Advocate Nikhita, usually we receive all the queries about the property disputes and the ways to curb them. But then we also sometimes, the NRIs who are living miles apart, they get very emotional and they are very frustrated that why these disputes happen to us, like why are we put into all this trouble. So would you like to put some light on main causes of these disputes?
I would love that, Alicia. So basically, see, these are the normal queries which we keep on asking, and it is very important for every NRI residing so far that to keep a proper control over the property. Control is the essence of everything. Now what we can do is, the main causes, what happens is there are unclear ownership or title records. They are unclear, they are unambiguous. Proper documentation, when there is no proper documentation, which leads to disputes, future disputes regarding the property. Then there are fraudulent sales, which happen. Then again, there's a reason that they will give power of attorney to any ABC person, and of course, without having that proper faith in that person, that particular person can, misuse the power given to them, power given to him to deal with the property, can enter into any third party transactions. Then again, I would say appointing a caretaker.
Exactly.
Like, there has to be, you trust a person without documentation, because you are sitting that far and it is very difficult for you to have a control over this, over your properties. So जिसमें भी आप इन्वेस्ट कर रहे हैं अपना जिसमें भी आप अपना इम्पोज कर रहे हैं फेथ, so you have to be very sure, it needs to be documented. It is as simple as that, because even if you are approaching the courts, we are lawyers, and of course we will recommend you this thing. There has to have a documentation. Emotionally, you cannot get that, to be very honest. But then documentation होना बहुत जरूरी है. अगर आप power of attorney दे रहे हैं, make it in writing. Powers उसकी थोड़ी restricted रखिए, so that आप sale की power नहीं देते हैं. ये बहुत छोटी काफी points होते हैं that needs to be kept in mind. So I think that is it. And tenancy issues में एक मैं point बताऊंगी. Rental agreement थोड़ा आप देखें आपका properly drafted हो, और उसके अंदर जो clauses हैं that should be strictly made. So that's how it should
exactly.
be.
And while you were on it, we received a question that hello, what are the various ways to resolve property disputes in India? I think we've already explained it, but still
we have done it. Yeah, we've just been doing that thing only. See, outside court, inside the court. So these are the two ways of doing it. Outside the court, जैसे हम अगर we can just put it in a brief of what Alicia started with. Mediation is outside the court, but when the matter is in the court, we can do it within the court. The matter can be referred to the mediation. Then there are family settlements. If you are doing outside the court, the family settlement can be entered into. If there is a litigation going on, the family settlement can be drafted during the court proceedings. So these could be the ways how you can resolve it. But then again, as I just explained to you, there are causes of these disputes to be happening. But then you can always prevent them from happening rather than getting into them. But once you've gotten into them, of course, we have resolutions as well for you.
Yeah, you need to have a very proactive approach, I think, to prevent all these disputes sitting miles apart. And we have another question which says, Madam, I have made a compromise agreement with my brother regarding our ancestral house dispute, but now he is refusing. What can I do? Again, a question on compromise deed. So I would again say, see, if your brother has entered into a compromise deed, it is a settled law that he has to abide by it. Because if both the parties have signed it, it is presumed that he has entered into the compromise deed without any undue influence or any pressure. But however, if he refuses to do so, you can always approach the court and you can get the compromise deed upheld. Yeah. Now we have a lot of questions coming up, and another question is that, hi, I am a resident of UK. I own properties in Karol Bagh, Delhi. How can I prevent property disputes living abroad?
Alicia, I'd like to take up this question.
Okay.
Again, it is related to what I've already explained, that how you can protect the properties here. Updating the title records is one of the most important thing, that you have to keep your records, documentary records updated. That is very important. Then to have a physical control over the property, how you can do it? Of course, you are there. Since let's take an example that you have a vacant plot lying here in India, somewhere in India. It's better to have a fencing or a boundary wall being made up around that plot. So don't leave your plots vacant like that, because it's very difficult then to get them demarcated, and of course the boundary has to be demarcated. So that is another thing. Then giving a power of attorney to a trusted person, which becomes very important. And then I would say, I think pretty much covered up.
Yeah, almost all the, I think, the reasons we've covered. And I see another question which says, good evening, my uncle wants to divide the property of his father between his brother and sister. However, one brother is saying that on basis of oral settlement, the entire property belongs to him. What to do in such a situation? Well, since it's a family matter, firstly I would highly recommend you that you try and negotiate, right? Because siblings are involved in this matter. You try to negotiate it at the pre-litigative stage so that you don't have to approach to the court. even then, you know, if this brother of your uncle resists and he does not comes to the common or mutual terms, then obviously you have the resolution litigation. You can go to the court, and once you know that pressure is there from the court, then he might come up and, you know, admit his share, whatever the equally divided share that is coming to all the siblings. So that's the resolution, and for the time being we do not see any question as such. I think we have covered every
almost
every
points
question,
have been
yeah.
covered. I would like to wrap up this session by, you know, just briefing it up. Of course, we have told you how you can resolve your matters amicably. So that is one part of it. But then, of course, we already are aware there will be a lot of cases where the matters cannot be resolved amicably. We will have to approach the court. It is a crux of it that matters, if can be resolved amicably, should be you know, considered. Proper documentation for that also is one scenario. If matters cannot be resolved in an amicable way, then approaching the court is the only resolution to get your property, get your interest protected. So that was the, I think, session for today, and
Yeah.
I think Alicia would.
And we thank all the viewers for your support and for your queries. It really shows your curiosity, and we'll be back with all these enlightening sessions in the future as well. So stay tuned.
Yeah. Thank you.
Thank you.